of soil. They will ask one question: what is the son of soil? The first answer is the 2020 announcement by the Madhya Pradesh government to resolve all government job children of the state. Raise for the questions fundamental right to equality. Constitutional provisions on this issue. Legislation son of a soil is constitutional provision. Also ask Article 16. Guarantee equal treatment under the law of a matter of public employment and prohibition that the state form the district discriminating on the ground of a place of birth or residence. Article 16, subsection 2, no citizen shall on the ground only religions, race, caste, sex, distance, place of birth, residence or any of them be ineligible for or discriminating against the respect or any employment of or office under the state. The provisions is the supplemented by the other clauses in the constitution that guarantees equality. Okay. The son of soils in the son of soils, the traditional state of issue the legislation for the son of soils. First is 1984, Dr. Pradeep Jain versus Union of India. Second, 2002, the Supreme Court invalidated appointment of government teachers in the Rajasthan in the state of selection board gave the preference of applicant belonging to the district, the rule of area. Next is 1995, the Sunanda Reddy versus state of Andhra Pradesh strike. Okay, and 2019 struck down. Allahabad High Court struck down the recruitment of this. This is the son of soils. Now the provision is supplemented by the other clauses in the constitution that guarantee the equality. Article 16, subsection 3, provide an exception by the saying that parliamentary may make a law prescribing a recruitment of the resident for the job in the particular. Okay. Now, next is for particular job. Okay, this power is vested solely parliamentary, not state legislature, not state legislature. Okay. Next, why does the constitution prohibit reserve-based domiciles? India has common citizenship, which give the citizens liberty to move around freely in any part of the country. The requirement of the place of a birth or a residence cannot be qualified by public employment in the state. Okay. Now, next point is subcategorizations of other backward classes. In the subcategorization of other backward classes, important point: Justice Rohini Commission. They will ask what is the Justice Rohini Commission also. PDF. Okay. OBC reservation backward. First backward classes commission in 1953, then 1979, 1992, and 1992. 1992. Okay. First backward commission was set up in 1953 under the Kaka Kalikar. They will ask also Kaka Kalikar. Why are not Kaka Kalikar. Next, 1979, second backward classes BP Mandal. 1992, Article 60, subsection 4, 27% reservation. And 1992, creamy layer criteria involved by the Supreme Court in the Indira Snehi judgment 1992. Okay, so Indira Snehi judgment in 1992. They will ask in the is Indira Snehi judgment is 1953? No, it is 1992. Justice Rohini Commission. Justice Rohini Commission, 4-member commissions headed by the Justice G. Rohini, 2017, under Article 2. Under Article 340, with aim with improve the quality, equitability for sharing of benefits among the OBC. OBC is a collective term used by the government to classify the castes which are the educationally or socially disadvantaged. OBC are referred as the socially and educationally backward classes. Article 340 of the Indian Constitution laid down the condition for the appointment of the commission, investigate the condition of a backward classes. Mandate of the commission: examine the extent inequitable distribution of benefit reservation, work out the mechanisms of criteria, norms, and parameters in the scientific approach of subcategorizations of OBC. It is not all important this type of things, not objective type. Okay, the commission has proposed to the divided OBC into the 4 subcategory number 1, 2, 3, 4, and split 27% into 269 and 10% respectively, according to the 11 state UT or United Territories: Andhra Pradesh, Telangana, Puducherry, Karnataka, Haryana, Jharkhand, West Bengal, Bihar, Maharashtra, Rajasthan, and Tamil Nadu. We have a subcategorization of OBC for reservation in subcategorized own institution. First of all, here the some National Commission for backward classes. So they ask also what is the National Commission backward classes, or it is the statutory body or government or constitutional body. The first is the NCB is the set up in statutory body. Okay. Under the NCB Act 1993, 100 which constitutional amendment act mandate to the National Commission backward classes. The 102nd constitutional amendment act made in the constitutional body as per Article 338B of the Constitution. Key function of this, they also ask this key function. In the case of a grievances of the related to the non-implementations of reservations, economic grievance, violence, and etc., people will be able to move the commissions to inquire into the complaint to the deprivations of rights and the safeguard. Now next is development with regarding 102 Second Amendment Act. 102nd Amendment Act, Article 338B and 342A in Constitution. Article 338B deal with the structures, duties, and power of the National Commission for Backward Classes Commissions, and Article 342A with the 2 clause which give the President the power notify the class SEBC and the power of the Parliament alert to the Central CBC list. Recently, Ministry of Social Justice Empowerment has framed the amendment to Article 342A, 127th Amendment, to introduce the 3rd clause, Article 3242A, subject clause 3, restore the power of the identity of the OBC. Okay, Article 15 clause 4, Article 15 clause 5, Article 16 clause 4 expressly confer the power of the state identify the list of social and the educationally backward classes. Okay, related news: other backward classes of economic weaker sections get to Quato under All Indian Quato. They also ask this: what is this? It is get Okay, yeah, this. What is this? Economical weaker sections gets quarto under the All Indian Quarto AIQ schemes for medical courses, and Union Home Minister announced 27% reservations for OBC, 10% quarto for EWS in AIQ scheme. Okay, what is the AIQ? Also, they ask. It is the All India Quarto. Article 15 special provision for education. Provide a special for social educational backward classes, schedule caste or schedule tribes and admission education. This but didn't including in the medical and dental. They're not including in medical. Now, reservations of local body polls, moving that the reviewation petition, Supreme Court review the petitions before the Supreme Court allow the political image, obviously. Okay, strike down this Maya Krishnamurti judgment. Okay, not. Now we'll direct come to with the basic structure. What is the basic structure? Why in news? The first discussion on the Bharti of the landmark, Keshan on the Bharti, Shri Pandagalavuru, and other versus state Kela, this case, Keshan on the Bharti. After the Keshan on the Bharti, basic structures points come. Keshan on the Bharti judgment Supreme Courts outlined basic structure of a constitution. The case dealt with the against of the Kerala government challenging the compulsory acquisitions of the land of the government under the Kerala Land Reforms Act 1963 as a violation of a fundamental right, as in ensuring Article 25, 26, 31 of the Constitution of India. The case was heard by the bench of 13 judges. The largest form of the Supreme Court is hearing the proceed of the scope of the case, expanded address of the following interpretations on the of Golaknath case, interpretations of Article 368 power of Parliament amend the Constitution, the validity of the 24th Constitutional Amendment Act Section 2 and 3 of the 25th Constitutional Amendment Act 1929 Constitutional Amendment Act. Various elements, there are also, this is also important point, various elements of the basic structure. Some principles are presently part of the basic structures are stated below. Sovereignty of India, essential features of the individual, freedom secure of to the citizens, mandate to build a welfare state, supremacy of the constitution, republican and the democratic form of the government, secular and the federal charters of the constitution, separations of power between the legislature, executive and the judiciary, unity and integrity of the nation, power of the judicial review, harmony and balance between the fundamental right and DPSP, parliamentary system, then rule of law, principle of equality, freedom and fair elections, independence of judiciary, limited power of parliament to amend the constitution, effective access to justice, principle or underlying the fundamental rights, power of the Supreme Court under Article 32, 136, 141 and 42, power of high courts under Article 226 and 227. Now, evolution of a doctrine of a basic structure. First, parliament can amend any part of including fundamental. In 1951, Shankari Prasad case, in Shankari Prasad case and 1965 Sajan Singh case, they both are parliamentary can be amended any part of including the FR fundamental rights. And in 1967, Golaknath case said that the Article 368 did not confer the amending the power to the Parliament, and also they said that the fundamental rights cannot be amended by the Parliament. Now, in 1971, 24th Constitutional Amendment Act, not a law. Okay, the Parliament can be amended, and 25th Constitutional Amendment Act, that the Section 2, curtailed to right to property with a due to compensation, and Section 3. Precedence purpose of the DPSPs over a fundamental right. Took away the scope of the judicial review for the 39B and 39C. In 1972, 29th Constitutional Amendment Act lent reform of legislation to the 9th schedule. In 1973, Keshan on the Bharti case. Keshan on the Bharti case, and now currently also it's overlap. The Keshan on the Bharti case is the line through. The Keshan on the Bharti line of the thought that the maintain and the strengthen in the subsequent judgment, like Minerva Mills case, SR Bomai case, and IR Koilo case. UA is under article and CA Constitutional Amendment is under article and UA is 13 under article 13. Okay. Outcome of the Keshan on the Bharti upheld the validity of 4th Amendment and the 24th Amendment Act. Okay. And provisions of the constitutions and the basic structures doctrine corrected the judgments of the Golaknanda case. Supreme Court's Article 368 contained the power of and the procedures for the amending the constitutions and amending the power of legislative power of Parliament were the difference. Now, other judgment of Supreme Court 25th and 99th Amendment, except a part of the crucial power of the judiciary review, asserting that the preamble is a part of the Constitution, hence amendment. Okay. Now, next is Uniform Civil Code, UCC. Okay. Why news? I'm not reading this. Why news? But the main point, which is related to the UCC, which is UCC provide one law for entire country, applicable to all all religious community. Okay, in their personal matters such as marriage, divorce, and inheritance, adoptions, etc. Article 44. They ask also which article related to the UCC? Article 44, Article 368, Article 22, which related? Article 44, which Constitution laid down to the state shall hand over to secure the UCC citizens throughout the territory of India. Status of a UCC, Uniform Code in India. Indian laws do follow Uniform Code in the most civil matters, such as the Indian Contract Act 1872, Civil Procedures Code, Transfer of Property Act 1882, Partnership Act 1932, Evidence Act 1872, etc. Now, recently the several states of refused that governed by the Uniform Motor Vehicle Act 2019. Goa is the only Indian state have a UCC in the form of the common family law. ओके बैकग्राउंड में શું ચાલ્યું છે बैकग्राउंड में क्या हो रहा है बैकग्राउंड में प्री इंडिपेंडेंस कॉलोनियल एरा में exclusive reports of October 1840 it stressed that the importance and the necessity of the uniformity codification codifications of Indian law relating to the crimes evidence of the country but the recommended that the personal law is the Hindus and Muslims should be kept in outside such a country codification not बार बार condition read करके codification को condition बना दिया B.N. Rao committee was formed codify Hindus law in 1941 they ask a B.N. Rao committee for which law it is for right to education right to food right to speech or right for Hindu laws answer is codify the Hindu laws in 1941 then post independence हुआ post independence में the Hindu code bill the Hindu this bill is drafted by the B.R. Ambedkar which will all know Hindu code bill B.R. Ambedkar reform the Hindu laws which is legalized divorce and divorce को भी मैंने divorce बचा divorce opposed the polygamy gave the rights of inheritance to daughters okay we not okay Hindu Succession Act 1956 amended to codify the law relating to interest of the unwilling successions among the Hindus, Buddhists, Jains and Sikhs. However, they are separate from the laws for Muslims, Christians and Parsi. Landmark court of the case of the order that the uniformity of court often said the judgment in the case of the Shah Banu case in 1985 and Sarla Mudgal case in 1995 and Daniel Latify case that the government should be moved toward the UCC. Yeah, इसमें important क्या था? एक तो ये point वाला important था. कुछ नहीं था. Anti-conversion law. एंटी कन्वर्जन लॉ क्या है वाई न्यूज व्हाट इज द बेनिफिट वेयर इज एंटी कन्वर्जन लॉ Karnataka Legislative Assembly passed the Karnataka Right to Freedom of Religion Bill, commonly referred to the Anti-Conversion Bill. Okay, states that have anti-conversion laws. Currently, at least 9 states. तो कितने 9 है? 9 states. उसमें ओडिशा है, okay, मध्य प्रदेश है, अरुणाचल प्रदेश, गुजरात, हिमाचल, छत्तीसगढ़, झारखंड, उत्तराखंड, उत्तर प्रदेश. ओ जा चा ही गु अरु मा ओ. ओडिशा, मध्य प्रदेश, अरुणाचल, गुजरात, हिमाचल, छत्तीस, झारखंड, उत्तराखंड, उत्तर प्रदेश. Now next is मतलब they have anti-conversion laws. Okay, history of anti-conversion law क्या है? History of independence दिखाई. I think this point is also important in the mains perspective, not for prelims. I think they ask also main acts related to this anti-conversion law, but we not read. Important courts verdict on the anti-conversion law. Okay, I don't know. No ask Sarla Mudgal. Sarla Mudgal case which also in UCC and also here. Official language now we direct in official language. Tullu speakers demand that official language status inclusion in HQ. देखो अब तुल्लू लैंग्वेज जो है वो तुल्लू किस आदिवासी की एक हिस्ट्री पॉइंट ऑफ व्यू आएगा. फर्स्ट ऑफ ऑल वी फाइंड ओके गूगल Tullu is primary spoken language to in Tullu Nadu, considering of the Dakshin Kannada and the Udupi district. Okay, Dravidian, which is Tullu language. Tullu speaker demand कर रहे हैं हमें 8 शेड्यूल में ऐड करो. तो फर्स्ट ऑफ ऑल हमें पता चलना चाहिए कि 8 शेड्यूल में कौन सी लैंग्वेज है. आसामी, बंगाली, गुजराती, हिंदी, कन्नड़, कश्मीरी, मलयालम, मणिपुरी, मराठी, नेपाली, ओडिया, पंजाबी, संस्कृत, सिंधी, तमिल, तेलुगु, उर्दू, बोडो, संथाली एंड मैथिली एंड डोगरी. लेटेस्ट इज डोगरी. नाउ कम इन दिस Tullu Dravidian language आ गया. इतना गूगल सर्च किया हुआ तो सामने ही है Tullu को क्या है Tullu is the Dravidian language spoken mainly in two coastal district of the Dakshina Kannada and Udupi of Karnataka and Kasaragod of Kerala. About the official language